everyone, welcome back to PI's The Break. Today we're here with myself, Clare, Irvine, the not director of anything, the Government Affairs Counsel. Brad is the director of Government and Industry Affairs, and he's here to talk about agency agreements, and more specifically, a couple key points in your agency agreements, and why those sections really matter to independent agents. So before I trip over my own tongue some more, I'll turn it over to Brad to go in more detail for these sections.
Thanks, Claire. I feel like I need to watch my back now. She's gunning for me, everybody. This is video evidence. If I disappear after this, we know who the main culprit is.
Yeah.
Thank you, Claire. As Claire mentioned, this episode of The Break is on agency agreements. It's September right now. We're recording this. When you're watching it, I don't know. It's time when agency agreements start to roll in. So we wanted to give everybody a high-level view of the agency agreement, what you should be watching for. As Claire mentioned, this is not at all comprehensive in terms of everything you need to do on agency agreements. It's not even comprehensive of the topics that we're going to be covering, but it is just to get you a little information on what you really need to be watching out for in these agreements. So first things first. Ownership of the book of business, ownership of the expirations. This is probably the most important aspect of an agency agreement. The book of business is literally your livelihood, right? This is what you've built your agency on. The agency agreement ideally should state unequivocally that the producer, the agency, owns the book of business. No strings attached, right? It is yours no matter what. That is the ideal. That is never the case, unfortunately. The vast majority of agency agreements are going to have strings attached. They're going to have qualifiers. What you're going to see most likely in an agency agreement is something that says the fact of agency owns expirations unless they owe money to the carrier. In that case, then there's a number of things that could happen. Either the carrier could take the entire book permanently, they could take part of the book to pay off the debt, and then return the rest to the agency. There's a number of different things that could happen. What you want to watch out for is that qualifying language in these agreements. Anything that says you own the book of business, but or except, those are the red flags, the accept language, if you will. So watch out for those strings. Oftentimes you can't negotiate them out, but at least you know about them. And knowledge is half the battle here, right? G.I. Joe. Next thing is commissions. Probably the second most important thing, right? Book is very important, but the commissions, that's where you make your money, right? We want to know what the commissions are. Unfortunately, a lot of agency agreements don't actually tell you what the commissions are going to be. Ideally, the agreement is going to specifically set out the rate of commission, how and when an agency will be paid, and also how and when commissions would change if they do change. Again, that's the ideal. That is very rarely the case. Most agreements are vague on this. You'll see something to the effect of commissions are addressed in Exhibit A, and maybe there's no Exhibit A attached, always problematic. Or the provision itself might be vague and not reference anything else. It'll say that commissions will be paid at the discretion of the carrier, or commissions can be changed at the discretion of the carrier, all problematic language. So be aware of that vague language, or if there is absence of language in terms of how much commission you're going to get paid, when that commission will be paid at the end of the month, at the beginning of the month, whatever it might be, and importantly, how it's changed. Oftentimes you'll see language that says the carrier can change the commissions without notice basically at their discretion. Not very good. We usually suggest that there's language involved that says that a carrier cannot change commissions for a period of 90 days or 180 days. The longer, the better. Obviously, we're talking about adjusting commissions down. If they want to adjust commissions up, great, do it tomorrow. But we're talking about the negative impact. So again, watch out for that vague language when you're looking at commission clauses. Next, talk about the indemnification and hold harmless clauses. Technically, they're different for legal purposes. For our purposes, they're really the same thing. They basically say that if you screw up, you promise to indemnify me or hold me harmless for any liability or damages that might arise from your mistake. These are pretty standard. You'll see them in most agency agreements, although not all of them. The key here is you want to make sure that these agreements, these clauses, are mutual. That means that if I screw up, I take care of the other party. If the other party screws up, they take care of me. Oftentimes, that's not the case. You'll see agency agreements, it's probably not surprising because they're written by the carriers, that require agencies or producers to indemnify or hold harmless carriers, but there's no reciprocal language back. So if a carrier messes up, the producer is still on the hook. So you want to make sure that those agreements are reciprocal. There's mutual language involved. I hold you harmless, you hold me harmless. We're both put in the same position. Again, so watch out for that, that one-way language. We want the two-way language. Next, the penultimate topic here, cybersecurity clauses. And this is a fairly recent one. The inclusion of these cybersecurity clauses have increased dramatically in the past couple of years. It's directly tied to New York's cybersecurity regulation, which went into effect a couple of years ago. More and more carriers are putting clauses into the contract that require producers to put in certain safeguards to protect non-public information that they might be getting from the carrier or they might have from the clients. I'm not going to go into those safeguards. That's going to be a separate break in itself. I have plenty of materials on that as well. What you want to watch out for in these clauses is clauses that go beyond what you're required to do by law. So using New York cybersecurity regulation as an example, the vast majority of licensees who need to adhere to that regulation are not required to encrypt data or use multi-factor authentication. However, a producer contract with a cybersecurity clause in it may require you to take those steps, even though the law does not. So you could be in violation of your agency agreement, even though you're not in violation of the law. So be aware of those clauses that go beyond what the law requires. They come up fairly regularly. You'll see them. They're going to be pretty long when you see a cybersecurity clause. It might be a couple paragraphs or even a couple pages. Those are the ones that are really to watch out for because they're going to put extra steps in terms of what you need to do for cybersecurity. And then finally, termination, the end of the agreement. The vast majority of agency agreements go in perpetuity. They don't end ever in terms of having a natural end date. However, they do have provisions in them that allow both parties to terminate the contract. It's going to spell out how you do that. A lot of times they'll say you can cancel a contract without cause as long as you provide notice to the other party. Sometimes there will be a for-cause cancellation as well that allows either party, generally speaking the carrier, to terminate the agreement more quickly. But again, generally speaking, there's going to be a notice provision that says you need to give 30, 60 days, something like that. Now, what you need to watch out for is when those termination clauses provide less protection than the state does. For example, you might see 30 days a lot, but many states like New Jersey offer a longer period of time. So state law will always trump this. The contract cannot reduce the protections there. But you need to know that in order to enforce your state law rights. If you don't know that, the carrier is just going to say, well, 30 days, that's when the contract, and you're going to go along with it, even though the state says you can have longer. So be aware of what the state laws are as opposed to what the contract says, because there likely will be a difference. I should say that we have a lot of resources on agency agreements. They will be included, or they are included below this segment right now. In addition, one of the services that we provide at PIA, Clare and I in particular, is reviewing these agency agreements for our members. We are attorneys. We also play them on TV. We will review these agreements for you and give you a sense of what to watch out for, the red flags and that sort of thing. So I'd highly encourage you to send the contracts to us because honestly, Claire and I strangely enjoy reading these things. We're weird like that. So we'll help you through this process to, again, let you know what's going on, because these contracts change a lot. As I mentioned with cybersecurity, that's a new thing. There's a couple other new items that are being added to agency agreements. So it's helpful to have, I guess, a quote unquote expert review them to let you know what we might see. With that, if you have any questions or you do want to send a contract for review, please send it to the Resource Center, or you can send it to Claire or I for review. With that, I'll turn it back over to Claire for any questions, and if there's none, we'll adjourn.
Yeah, you could go on for an entire day about just details of these contracts specifically. I'll just note that the contracts you receive from the agents from any carrier are written by the carrier's lawyers. So it's good to have Brad, myself, or an attorney representing your agency review it just to make sure that your interests are also protected for what was in the video and other issues that may be written into those very legal 10, 12 even more pages.
It's a great point, Claire. That's right. The carrier does write the contract, so it is good to have somebody in your corner to look at it. All right. Any questions, Claire? Anything to end besides that?
No, just the best place to send it for particularly the contract is probably the Resource Center, because we also, that helps with our filing.
Absolutely.
Much as we like getting those directly, the Resource Center is the organization.
The Resource Center, exactly. All right. Well, thank you, Claire.
Thank you,
appreciate
Greg.
it, and thank you all for watching, and we'll see you again soon.